I had two feelings at the exact same moment during this case. I felt the weight of a child who had been made to disappear inside a stack of false documents, and I felt something I can only describe as quiet, the specific kind of quiet that arrives when you understand that something broken is about to be repaired. I had never felt both of those things at exactly the same moment before this case. I have felt them together ever since. This is why. I want to ask you something before I keep going. Have you ever watched someone choose to be careful with a child they did not have to be careful with? Have you ever seen a person decide, not because the law required it, but because they were still capable of deciding that a small human life was worth protecting? Subscribe, because that is what is coming in this story, and I need you to be here when it arrives. The child's name was Marcus. He was 7 years old when he entered the foster care system in Cook County, Illinois, on March 4, 2019. His biological mother's parental rights had been terminated following a prolonged neglect proceeding. He was placed with a licensed foster family within 11 days. They had been licensed for 6 years. No prior concerns. For a child who had already lost the first thing a child is supposed to keep, this looked like solid ground. It was not. When Marcus came to my courtroom for the first time, not to testify, but because his case guardian had requested his presence, he walked in holding a drawing he had made that morning. He had asked his guardian whether he was allowed to bring it. He folded it and unfolded it twice before he sat down. I noticed that. It was the act of a child who needed something to hold and who had chosen something he made himself. That detail has lived in me since the first day of these proceedings. It still does. The defendant was Dr. Elliot R. Harmon, licensed pediatrician in the state of Illinois for 22 years. He had a practice in the western suburbs and served as the contracted medical provider for 17 foster children in Cook County at the time of the offense. When he sat at the defense table, he kept his hands flat on the surface in front of him, not folded, not restless, flat. I have watched many people sit at that table. That specific stillness, the kind that comes from someone trying very hard to stay controlled, told me something about how much effort he was putting into not falling apart. I needed to see that. I also needed to see what he had done. Both things were true at the same time, and my job required me to hold both of them without setting either one down. What happened began on September 9, 2019, at approximately 10:40 in the morning, at the Harmon Family Medical Group on Oak Street in Elmhurst, Illinois. Dr. Harmon saw Marcus for what was documented as a routine well-child visit. The foster family had brought concerns. Marcus was wetting the bed, waking in the night, showing reluctance to engage with adults in the home. These are common trauma responses in children moving through the foster system. Dr. Harmon knew that. He had been working with foster children for nearly a decade. What he documented that morning was not what he observed. He wrote that Marcus showed signs consistent with a developmental delay. He documented a behavioral screening score that Marcus had not actually received that day. He noted a recommendation for a specialized behavioral program, a program affiliated with a service organization from which Dr. Harmon received a referral fee. The screening score, the developmental finding, the recommendation, none of it reflected what was in front of him. Marcus was not developmentally delayed. Marcus was a child who had been through something hard and was doing exactly what children who have been through hard things do. Dr. Harmon said this in testimony on November 14, 2022. I told myself it was still within the range of clinical judgment. I set the pen down and looked at that sentence for a moment before I wrote it. If you are still with me, you have probably gone quiet. Whatever was happening around you has probably faded a little. Subscribe. That kind of attention deserves the rest of this story. Subscribe and turn on notifications. When the case file reached my desk, it was November 2022. The Illinois Department of Children and Family Services had flagged the falsified records after a new caseworker named Priya Mehta, 7 months on the job, cross-referenced Marcus's documented medical history against a developmental evaluation his school had completed that October. The school evaluation found no developmental delay. The school psychologist had tested Marcus thoroughly and found a child who was perceptive, verbal, and age-appropriate in every measured category. Priya Mehta made a call. She pulled the original record. She compared. She filed a report. I want you to understand what that cost her. She was 7 months into a job that already asked more than most people realize. She filed against a physician whose name was on paperwork she had inherited her first week. She filed anyway. The grace current in this case began with her. I traced it back to her the way you trace a river back to its source. The legal charge was a felony under Illinois Statute 720 ILCS 5-17-3, forgery of a document affecting a civil transaction, combined with a second charge of medical record falsification involving a minor. The first charge was a Class 3 felony. That classification gave me meaningful sentencing discretion. I did not have to default to a mandatory minimum. I could design a ruling rather than simply deliver one. I knew from the moment I saw the charge sheet that I had room to hold both rivers in the sentence. That room mattered to me enormously as I carried this case through the weeks before sentencing. There was an afternoon, November 29, 2022, a Tuesday, when I had the case file open to the fabricated screening form on one side and the school evaluation on the other, the false one and the real one, side by side. I felt both rivers in the same breath. I set both pages down. I sat with that for a while, then I kept reading. Here is what I am offering, the rest of this story, told exactly the way I have been telling it. Nothing held back, nothing resolved before it is ready, nothing softened because the softened version is easier. Subscribe if that is what you want. I will keep going. The first witness in the evidence phase was Marcus's school psychologist, Dr. Adeola Owusu. She had tested Marcus in October. She spoke about him the way evaluators speak about children they have genuinely paid attention to, with specificity and with the kind of professional honesty that comes from someone who understands that words in a file follow a child for years. She said, Marcus scored in the typical developmental range across all domains. He is a curious child. He has strong language skills. He told me he likes drawing because, in his words, the paper keeps it. She said it plainly. I wrote it down. The grace current ran through that sentence at full strength. The sorrow current arrived through Daniel Torres, the Cook County child welfare specialist assigned to Marcus's case in April 2020, 7 months after the false record was created. He testified that when he reviewed Dr. Harmon's documentation, he had accepted it. He had not questioned it. He had begun coordinating a transfer for Marcus to a specialized behavioral placement based on the fabricated recommendation. He said quietly on the stand, I processed the record as though it was true. He was not being evasive. He was telling the truth about how systems work, how busy people in underfunded departments absorb what they are given. The sorrow in that sentence was not his fault. It was a fact about what false documentation does when it enters a pipeline and begins moving downstream. The moment both rivers were present in the same evidence was a letter, Exhibit 19, written by Marcus's foster mother, Sandra K. Osei. She had submitted it voluntarily after learning the records were false. She wrote, I brought his concerns to the doctor because I thought he would help us understand Marcus. I took those records home and read them 3 times. I thought I was missing something. She wrote that she had spent 4 months asking Marcus if he was okay, in the way you ask a child you have been told might not be okay, with too much gentleness, too much vigilance, too much watching. She wrote, I think I made him feel like there was something wrong with him. That letter carried both rivers simultaneously. A woman who had chosen to love a child she did not have to love, given false information that changed how she held him. Both things lived in every sentence she wrote. I read it 3 times. After I admitted Exhibit 19, I noticed Daniel Torres in the gallery put his hands over his mouth. He did not move them for a long time. That came from the confluence place. Not grief alone, not relief alone, but the specific feeling of understanding something you should have caught, understanding why you didn't, and feeling the weight of a child who carried what neither of you knew was false. I just realized, saying that out loud, that I had never put that into words before today. Subscribe. Because what I'm about to tell you about what Dr. Harmon said on that stand is going to matter more once you have heard what Sandra O.C. wrote. Subscribe now. The defense argued that Dr. Harmon had operated within what his attorney called a zone of interpretive discretion, that behavioral screenings contain inherent subjectivity, that his documentation reflected his clinical impression, and that the referral was made in good faith. I heard that argument carefully. There was one moment that surprised me. It came when the defense introduced a letter Dr. Harmon had written into Marcus's case file in March 2021, a full year before he was charged. The letter had been found during the investigation. He had not sent it. He had not filed it. He had simply written a note into a folder no one had requested, describing his documentation as, in his words, a judgment made in a moment of clinical stress. The grace current ran through it faintly, not because it excused what he did, but because it showed that somewhere inside him, before the law arrived, something was already unsettled. The defense could not resolve what the sorrow current contained. The fabricated record had moved through a real system and reached a real child and changed a real woman's relationship with him for 4 months. Those were not impressions. They were what happened. Dr. Harmon testified on November 18, 2022. Near the end, his attorney asked him to describe what he was thinking when he filled out that behavioral screening form. He was quiet for a moment. Then he said, "I think I had decided that the placement needed support, and I went looking for the documentation to justify what I had already decided. I wrote it down. I looked at it for a long time. Both things I was feeling were in that one sentence. I did not expect that. When I was 34 years old, I sat in a room at Northwestern Memorial Hospital with my older brother, James. He had just received a diagnosis that changed the shape of the next several years of our family's life. I watched the attending physician speak to him in language that was technically accurate and humanly insufficient. Things had been written in James's record, not false things, but things documented quickly, with language that did not match what was actually present. My brother was not his chart. He was the person sitting next to me, pressing his back straight in a plastic chair, because that was what he did when he was trying not to fall apart. I thought about that room on the day I read Dr. Harmon's testimony. I thought about what it costs when the document stops matching the person. I placed that memory next to this case and let it stay there. I want to stop here for just a moment. Not for effect, because what I just said is something I have not said in any courtroom or any professional conversation. This case took me there, and I need a second with that. Subscribe while I take that second. Subscribe and stay. Okay, let me keep going. The room before I spoke, the sentence was still in the way rooms are still when everyone in them is holding something. Dr. Harmon sat with his hands flat on the table. Sandra O.C. was in the gallery. Priya Mehta was 3 seats to her left. Marcus was not present. He was 8 years old, and this was not a room he needed to be inside. His case guardian was there. I had decided carefully. I had decided knowing that this ruling had to hold the weight of what was lost and also leave room for what might still happen. Those two things do not always fit in the same ruling. In this case, they did. I had made sure they did. The verdict was guilty on both counts. Dr. Harmon's head dropped once, then came back up. Priya Mehta did not move. Sandra O.C. made a sound that was not quite a breath and not quite something else. I gave the room 8 seconds. Then I began. I am ordering you to pay $47,500 in restitution to the Illinois Voices for Foster Children Fund, designated specifically to support independent medical evaluations for children whose records show referrals to fee-affiliated providers. This amount was calculated specifically. It represents the approximate cost to review and independently reevaluate the 17 children under your care during the period of this offense. What was broken was not just one record. It was the foundation of medical trust for 17 children who could not advocate for their own files. This restitution is the beginning of repairing that. I am also ordering 24 months of supervised probation, during which you will perform 1,000 hours of direct community service at a licensed pediatric clinic serving uninsured children in Cook County, not in an administrative capacity, but in a clinical one, under supervision, providing care you will not be compensated for. You will do the work itself. You will be present with the children. I am ordering this because the evidence showed me that you are a physician still capable of the work when the incentive structure is removed. That is the specific design of this requirement. And there is one more thing. I am ordering you to submit within 60 days a written clinical protocol reviewed and approved by the Illinois Department of Professional Regulation for how behavioral screenings in foster children should be documented independently of referral relationships. This protocol will be distributed to licensed foster care medical providers in Cook County. It will carry your name, not to honor you, because the knowledge that produced the wrong you committed is also the knowledge required to prevent it from happening again. I am putting that knowledge where it can do something. You will also attend, for the full duration of your probation, a monthly accountability meeting with a DCFS-appointed case supervisor and 2 representatives from the foster care community. Those meetings are not optional and they are not procedural. They are relational. They are how you stay connected to both the consequence of what you did and the possibility of what you can still do. If, at the 18-month mark, your supervising officer, your clinical supervisor, and both community representatives provide written confirmation that you have been present, transparent, and genuinely useful, not performing those things, but doing them, I am authorized and prepared to consider early completion. I am including this not as a gift. I am including it because I believe, on the evidence, that you are capable of earning it. That belief is not the same as forgiveness. It is something more specific than that. Now I want to speak plainly. I want to say what I said in that courtroom and say it again here. You falsified the medical record of a child who had already lost the first things children are supposed to keep. You put a false diagnosis into a pipeline that was going to carry it forward, and it moved, and it reached the woman who was trying to love him, and it changed how she held him for 4 months. That is what you did. I will not make it smaller than it is. To Marcus, and to every child who sat in a waiting room while an adult decided the paperwork mattered more than the person in the chair, what happened to you was seen. It was read carefully. It was held by people who did not put it down. You were not invisible in this proceeding. You were the whole reason it existed. To you, Dr. Harmon, you are a person who made a choice that caused real harm, and you are also the person who wrote a note into a folder no one asked for a year before the law arrived because something in you already knew. Both things are true. I am ruling on the first one. I am not blind to the second. To this room, to everyone who came in here carrying what this case cost, what we are doing right now is not a resolution. It is a direction. That is what a courtroom can offer. It cannot give back what was lost. It can point toward what is still possible. The paper keeps it. That is what Marcus said. A child who needed something to hold chose something he made himself. That is a fact. That is the whole case in one sentence. You just heard what I said to him in that courtroom. Subscribe before we go further, because what happened after I said it is the part of this case I have thought about the most. Subscribe now. After I spoke the sentence, the room began to empty slowly. I stayed on the bench. Sandra Ose stood and walked toward the exit, then stopped beside Priya Mehta. She said, "Thank you for making the call." Priya Mehta said, "I almost didn't." Sandra Ose put her hand briefly on Priya Mehta's arm. Then they walked out separately. I picked up Marcus's real case file, the one that began the day Priya Mehta filed her report, and set it squarely in the center of my desk. I did not open it, I just put it there. Then I stood up. Then on April 11th, 2023, 4 months after sentencing, I received an update from the Cook County DCFS liaison monitoring the restitution process. The independent medical reevaluation of all 17 of Dr. Harmon's foster patients had been completed. In 15 of the 17 cases, the independent evaluations produced findings different enough to require changes in care plans, school placements, or referral recommendations. In one case, a 6-year-old girl, the independent evaluation identified an actual hearing impairment that had not previously been documented. She was fitted for hearing aids on April 8, 2023, 3 days before the liaison wrote to me. I read that line twice. The sorrow of what had been missed was in it. The grace of what had been found was also in it. Dr. Harmon's attorney filed a motion for sentence modification in February 2023, arguing the community service requirement was disproportionate. The motion was heard by the Illinois First District Appellate Court. The modification was denied on June 2, 2023, 4 months and 14 days. When I was informed of the decision, I felt something I do not have a clean category for. Not triumph, not release, but a specific steadiness. The steadiness of something built to hold weight that held it. This case showed me something I am still working out. Not about medicine or the foster care system, though it showed me things about both, something more interior. I have been thinking about what it means to hold grief and grace simultaneously and rule from that place rather than choosing one and setting the other down. I had been a judge for 14 years before this case. I do not think I had done that fully before I had approached it. This case asked me to stand inside it, the most honest thing I can say, the thing I have not said in any other professional context, and that this case produced in me with a clarity I did not expect, is this. A courtroom that pretends one feeling is sufficient is not telling the whole truth. The most honest sentence is the one that carries both rivers all the way to the end. If you are carrying the sorrow current of this story, if you know what it is to have been a child whose record did not match who you were, or to have held someone while a system processed them as something smaller than they were, I want to speak to you directly. I watched something shift in Marcus over the course of these proceedings, not because the loss disappeared, it did not disappear, but because the room kept choosing to see him accurately. There is a specific change that happens in a person when the record begins to match them again. I watched it happen slowly. The sorrow did not erase it. Both things were present. If you recognize yourself in Dr. Harmon's position, if you are sitting with a choice that caused real harm and trying to figure out what comes next, I have watched people in that chair respond in two directions. The ones who moved towards something were not the ones who argued the least. They were the ones who stopped managing what they had done and started being honest about it. The door does not close because of what you did. It closes if you decide you are only what you did. Those are not the same thing. That drawing, folded and unfolded twice, held in the hands of a child who asked if he was allowed to bring it. That is why I told you this story. Subscribe. Leave something in the comments if you felt both things at once while you were here. That is the room where people who are willing to carry two feelings find each other.